will not be that long because we will already talk about some of it in detail today. Okay? By the way, this is hot, so be careful. Okay? Safety concerns. So this was the last slide, no? You remember? Yeah. Okay. And so what's competition and competition law? Maybe the most important thing on this slide is competition law protects competitive process in the market, not the individual competitors. Okay? Goals, objectives of competition law. Important to know that there is no one single objective of competition law. There are several of them, and it's actually competition law quite flexible in terms of its goals. It is closely connected to the political views at the time. So, and we will see in a bit, there are different potential objectives, and those can change in different times considering the political policy. Okay, so at a certain point of time, we can say that these are the focus of these are the objectives, goals that competition law focuses now. And then there are some secondary, intermediary goals of competition law. And currently, as we will see, focus is on economic efficiency and consumer welfare. So I noted like some potential goals and objectives here. As you can see, the first one is economic efficiency and consumer welfare. So what do you understand from economic efficiency when I say economic efficiency? What's economic efficiency? Is there anyone studied economics here? Probably. You're hiding, I will find it. No? What's economic efficiency? Something related to economy, it should be efficiency. So what do you understand as lawyers or people having legal background from economic efficiency? Yes? Okay, so if there's that, if you can create that ideal free market, we can say that there is economic efficiency. So what happens if you have that, like supply, demand meets on equilibrium, and who benefits from that?
Customers.
Customers. Okay. What about undertakings? Companies like doing business? Do you think can they benefit from that? Okay, yeah, I'm seeing this. Okay, yes, I mean, how I explain, as we don't have any economists in here, I think I'm in a safe place to talk about like what I understand from economic efficiency. Disclaimer: this is not the definition of economic efficiency. Okay, if you go and check textbook on economics, probably microeconomics maybe, you can find definition, like a textbook definition. But for me, when I see economic efficiency, I start thinking about, for example, you can be in terms of like, let's say you're a company, you always like constantly look for ways to be more efficient, for example, in terms of your manufacturing, no? So what you can do in terms of being more efficient for your in your manufacturing. Okay, using scale of economics. So if you produce more, so let's say you are, can I use this?
Yeah.
this is earphone. So if you are producing this, if you start to produce more of this, you can reduce your cost for this thing, okay? Because you start to get your let's say raw material or component of this like cheaper because you are buying more, and so you start to produce, so you can reduce your cost per product. Also, maybe changing the location of your factory. No, I mean, do we have that many big factories in the West now? No. They are generally in other countries that they can produce with lower costs. Also, for example, you can think about distribution efficiency. How you can distribute your product more efficiently, no? So let's think about the example of Apple, okay? So we have Apple store in Buchanan Street, no? So Apple is manufacturing its own products and then also distributing its own products with its own store. So that Apple store is owned by Apple, okay? But it's not the case like all the time. Sometimes undertakings, companies can decide to distribute their products through third parties. And for that like example, and because they can implement different policies in different strategies in different markets. For example, till 2014 there was no Apple store in Turkey, okay? There was this third-party distributor called Kupa, and they were distributing Apple products. Their stores looked like Apple store, like a white, really sleek, clean, but that wasn't Apple, okay? And then they decided to enter Turkish market themselves, and they opened this like a art store, which is like art. Architecture is like really weird, like covered with glass and thing. So what shows that to us, till 2014, they thought that it wasn't efficient to be in the Turkish market as a distributor. But then something changed, maybe many things changed, and they said, okay, it will be better for us to be in this market and let's distribute our products by ourselves. So why they are making all these decisions, doing all this stuff more efficiently, okay, to reduce their costs, to do these things, and as a consequence, I mean, in an ideal world, they are also reducing their prices of their products. For example, if you take my iPhone, back of it is said design in California, so saying that design, innovation, and everything is in the US, but manufactured in China, okay? And if you think about it, if it's designed and manufactured in US, probably the cost of iPhone will be higher, okay? So it's closely, again, I'm saying that this is not the textbook definition, but this is what I understand as a lawyer when you say economic efficiency. So doing your business more efficiently and consequently reducing your costs and also reducing your prices for the customer. So it make it more accessible for everyone. So it is closely related to consumer welfare as well. And it's why it's important to know that now economic efficiency is the goal of competition law, and it wasn't like that before. Now economists are more involved in assessment of competition law. Before 90s, and we call that modernization of competition law in the EU, there were more lawyers, legal people in the commission. After this modernization and accepting that economic efficiency is the goal of competition law, now there are more economists assessing the issues from an economics perspective as well, okay? We always look at what is the, not always, in principle we look at what is the real effect of this agreement or conduct on the real market, okay? Second one, realizing regional policies, and we can say that this is like, in general, this can be goal of competition law, but also in EU we have this like unique goal beside economic efficiency and consumer welfare. So in the EU, one of the objectives of competition law is also single market integration, okay? So we try to remove the boundaries between member states through competition law mechanisms or using competition law, okay? And protecting competitors, as I said, it's not the main goal, but what can happen is that while you try to achieve that final goal of economic efficiency and consumer welfare, on your way you can protect competitors, okay? And we will talk about this today. In some cases you will see that actually we are protecting small and medium-sized enterprises against big undertakings, not just like I'm just like highlighting it like again and again. It's not the main aim, but it can happen because if you don't protect, if they are not protected, then you cannot also have economic efficiency, because you cannot have healthy competition in the market, okay? If you think that if you have a market that there are just few market players, like a really big market players, it's not that healthy. We always want to have as many as competitors in the market, or at least we want markets that can be, and like that undertakings can enter it, okay? Like no boundaries, barriers to entry to that market. Liberalization of regulated sectors, promoting innovation and growth. Yes, again, this is this can be categorized as secondary goals, and for example, promoting innovation, and which is really closely related to our topics in this seminars, and we will see how competition law can promote innovation. And justice, fairness, non-discrimination, I personally don't believe that competition law concerned about these things that much, but if you look at it like fairness or non-discrimination, they are general principles of law. So when you are enforcing any kind of law, regardless of competition or anything, they are they should be considered. Redistribution of wealth, I don't know. It's your call, but yeah, I don't think that competition law currently focuses on that much. And consumer protection, again, this is like similar to protecting competitors. It's not main goal, but it should be done in order to ensure economic efficiency and consumer welfare, okay? But it's not like the main target of the competition law. But you can see in some regional level, state level protection. For example, UK's competition authority, CMA, it also has the responsibility of protecting consumers. Or for example, if you go and look at Federal Trade Commission in the US, it has responsibility to protect consumers as well, okay? But it's not because it's the main goal of competition law or antitrust law in the US. It's just like for how they are organized in general. Any questions about these goals, objectives? I'm sorry. It's okay. Okay, I'm moving. EU-specific goals and objectives, I think we already talked about that. It's accepted that economic efficiency and consumer welfare, and besides we have integration of single market integration. So these few slides are referring to the founding treaties and some other primary sources of EU law that are indicating the goals of competition law. So if you go and look at these things, you cannot like clearly see that, okay, in EU goal of competition law is to protect economic efficiency and consumer welfare, but there are indicators. So I'm just like skipping them, and yeah. Important thing is consumer, okay? So in the context of competition law, consumer is not only real person and user, like me buying thing from, again, like Apple. It's broader concept, okay? And for example, if there is an agreement between two undertakings, two companies, let's say, for example, Apple is buying its screens from Samsung, if I'm not mistaken, or if they didn't change it. So when they have this agreement, because Apple is buying the screen from Samsung, for that transaction, actually Apple is in position of consumer, okay? It's broader concept than like us. So whenever you hear consumer, think about it can be company or again it can be a individual person, but it's broader concept than that. Source of competition law in EU, really quickly. Primary legislation, we have Article 101, and actually from 101 to 109, but we will mostly dealing with Article 101 and 102, okay? Article 101, and today we will talk about it, prohibition of anti-competitive agreements, concerted practice and decisions affecting the trade between member states. Then 102 is dealing with abuse of market power. And secondary legislation, regulations we have, and then directives. As an example, we can give for regulations, we have merger regulation. We will see there are regulations introducing block exemptions made by the European Commission. And then we have directives, and for that, which one is this? Directive is empower the competition authorities. Okay, this is like this is a new directive giving more power to national competition authorities to enforce Article 101, 102. But don't forget, these are examples. What's the difference between regulation and directive?
Regulation is it's the law you have to apply every detail, but a directive is kind of a goal, but you can change. You just to achieve the goal, but the way you achieve it is different. You can.
So, and how like
directive, the states need to implement norms inside within the states.
Mm-hmm. Which one?
So directive.
Directive. So they have to implement. So member states. Yeah. Okay. They have. What about regulation?
They're automatically applied.
Okay.
They don't have to do anything.
Yes. So this is for. Can you repeat it?
I think you said
Okay.
something from
No. Yeah. So who is coming
right.
from Europe, EU? Okay, I want one of you to give like a proper definition to that, like answer to that. Difference between directive and regulation.
Regulation is directly applicable. That means the member states doesn't have to implement implemented in
Loud,
national
loud,
law.
loud, loud.
The member states doesn't have to implement the regulations in national law. It's directly applicable. It directly becomes part of national law.
Yes, so it becomes part of national law when it's in force, okay?
And directives are not directly applicable. The member states have to implement them, and they have like a certain amount of freedom on how they want to implement the directive and how they want to achieve the goal of the directive.
Okay, perfect. Can you give an example? Regulation and directive.
The new GDPR is a regulation. It used to be a directive, but now it's a regulation.
Okay, so now I want someone from outside of EU to give me this answer for this question. Just like basically repeat. Come on, guys. So what did you understand from this? Nothing? Can I get from that corner? Either you or your friend next to you? Can you tell us like what is you yeah, I'm sorry, yeah. Can you tell the difference? Yes. No? Yeah, just yeah. Okay, can we say that, okay, so regulation is, member state do not need to do anything, it's directly applicable like the GDPR, General Data Protection Regulation. So when it's in force, it's directly applicable to all member states, okay? Whereas for the directives, member states should do something internally, enact like a piece of legislation or something to make it, to implement that rule into their domestic system, okay? And again, example is, for example, data protection legislation was directive before, so there were also piece of legislation at member state levels before for data protection, but now none because we have GDPR. Okay, clear? Good. Notices, guidelines, and communications, and we will see like there are so many things coming from Commission in that terms, like they are publishing notices, guidelines, and communications. And in terms of case law, we have decisions of Court of Justice and also European Commission's decisions. Okay? Let me see quickly. I'm not talking about these because we will like basically do this today. Just to again to highlight, these are the two main provisions that we will talk about: Article 101 and 102. So we will talk about Article 101 today and do the same thing for Article 102 next week. Okay? Any questions so far? No, everything is clear. So I'm moving to the. Okay. Before moving to this topic, let me ask you.
Yeah.
So what is the situation in EU if there is a work against public order? Didn't we talk last week?
Yeah.
And you said that in China you cannot publish.
Yeah.
You can get copyright, but you cannot publish.
I think so is in here.
Same here.
Same, yeah.
So you can.
You can have your copyright, but you won't publish it.
Okay. Did you look for the answer?
Yeah.
Okay. So we are 100% sure we can rely on your information.
Yeah.
Okay. We will not look like stupid if we tell this in somewhere else. So it's okay for us to relay, okay?
Yeah.
Okay. So we clarified if you remember this discussion or question from last week, if you have a work against by the way, I didn't check it, so I'm just like relying on you, and someone is actually even recording this, so I don't know. If you have a work against public order, you can still have your copyright, but you cannot publish in EU apparently, okay? Okay, let's move today's topic. So as I said, it will be about IP and agreements. So this is the outline. First, we will talk about elements of Article 101. We will not go through all the elements, and I just put the ones that we will focus on under it, because yeah, you are not. Maybe there are ones like studying competition law, but if you are doing that, these things will be discussed in detail in your competition law courses. For the sake of this course, we will just focus on the ones that enough for you to understand IP relation with competition law. Then we will look at Article 101, Paragraph 3, individual exemption. Then we will look at block exemptions, exploitation of IPRs, and finally agreements concerned with IPRs. Okay? And I also wrote some of them here. Are you cold? Okay, I'm turning this off. If you feel like roasting, just let me know, okay? Okay, let's start with.
Excuse me.
Yes.
I have a question about the reading list for this week.
Yeah.
You have put up Johnson and Zephyr's EU competition law.
Yeah.
Do you expect us to buy it? Because it's only 3 books available at the high demand, so it's very hard to actually access it.
Okay.
Since it's not an ebook.
So let me contact with the library. So how this work is, normally what we do is when we put this reading list before the semester, we also let them know about the number of our courses, and they check the number and they try to get like as many copy as possible to like enable you guys to get like had the chance to look at them. But obviously they didn't consider this course because it's just like for seminars. I will tell them, but my advice to you, maybe you can copy it, like one of you can copy it. Don't record this. Off the record. I mean, it's for educational purpose. So maybe if any of you have the book, maybe like the ones that who is actually specializing in competition or like taking. Okay, maybe you can just like talk to each other. I understand that it's like really frustrating. You go and you cannot find it. Maybe you can talk to, because you will always have the same pages that you need to read. So maybe you can do something, okay?
Yeah.
But I will write that to library after that. Okay. Article 101. This is the first 2 paragraphs of Article 101. So initially it says that the following shall be prohibited as incompatible with the internal market. All agreements. So what's following? All agreements between undertakings, decisions by associations of undertakings, and concerted practices which may affect trade between member states and which have as their object or affect the prevention, restriction, or distortion of competition within the internal market, and in particular those which blah blah blah. It's like long sentence, but initially it says that if you have an anti-competitive agreement, concerted practice, or decisions affecting trade between member states, they are prohibited. Okay, and there are some like some words are in bold and some of them are big because they are the elements of this article. Okay, so first we will look at agreement. No, first we will look at undertaking, concept of undertaking, then agreement, and object or effect. What does that mean? and affecting trade between member states. So we will look at what those mean. Before that, but just to clarify, if you have that kind of agreement, second paragraph says that this is automatically void. Okay, so this is the remedy of the first paragraph. So if you have this, your agreement is void. Okay, we will move to individual exemption. I didn't put it here because it's long, but we will talk about it in the following slides. Any questions about this article? Okay. First, undertaking. So what is undertaking?
Company.
Companies. Okay. So only companies in the concept of undertaking. Persons. Okay. So persons, what kind of persons? Because in law we have different kind
Natural persons, people like.
Yes, natural persons can be undertaking. Okay. So what is the key concept to understand whether we have an undertaking or not?
Sorry, it's any entity engaged in economic activity.
Yes. So the key word is engaging in economic activity. So it's a broad concept, okay? And this can be a legal person, company, or natural person, or maybe a public body. As long as they engage in economic activity, they are concerned as undertaking in the context of competition law, so they are subject to competition law rules, okay? So state agencies or quasi-governmental bodies, if they are engaging in economic activity, they can be subject to competition law. Only exception is if an entity is doing something that can only be done by public bodies or on behalf of public body. For example, and this is from one of the case, maintaining and improving air navigation safety. So if you are engaging that kind of activity, even you get a remuneration for your services, it cannot be considered as economic activity, so you are not subject to competition law. Again, another example is like protection of environment. Okay. Associations of undertakings, basically association of group of undertakings, obviously similar type of undertakings, and associations is entities defending their interest and protecting their interests, representing these undertakings. Okay, can you think of associations of undertakings, like as an example? I think, for example, Law Society of England and like Scotland, or in general bars, can be example of this. Okay, because they are associations of lawyers basically, and lawyers are engaging in economic activity. Any questions about undertaking? Okay, single economic unity doctrine. So this is actually subheading of undertaking. So do you know what's that single economic unity doctrine? No? When you, like, I think it's also like when you look at the title, it kind of gives some hints. Okay, so Article 101 cannot apply to entities between two or more entities if they form a single economic entity. For example, if you have a parent company and subsidiary, okay? So if parent company and subsidiary has an agreement between them, that cannot be subject to Article 101 because it's considered that they are, as a two of them, they create this big single economic entity, okay? So the test is, for example, if we again take the parent and subsidiary example, whether parent exercise decisive influence over the subsidiary, okay? So if parent is influencing subsidiary to a great extent, and if the subsidiary doesn't have autonomy anymore, then we said that they are single economic entity and any agreement between them cannot be subject to competition law, okay? And for that you can consider the shareholding structure of the subsidy, or for example, for that respect, you can look at whether actually parent is the controlling shareholder in the subsidy, or the composition of its subsidiaries board of directors, and also look at the similar transactions between the parent and subsidiary before, and try to see what was the influence situation in those previous agreements, okay? Anything about this single economic entity? What can be the practical implication of this single economic unity doctrine in terms of competition law? It's related to enforcement and so one thing is, for example, if you have a subsidiary in the EU, okay, and parent company is actually outside of the EU, because of subsidiary conducts located in EU, parent company which is outside of EU can be subject to EU competition law rules, okay? This can be one of the important implication. And the second one is, probably you all know that competition law is famous with its high fines, okay? Because fines in competition law imposed considering the annual turnover of the company. So if you're a big company and if you're making too much money, when you infringe competition law, you may need to pay a lot of money, okay? I think it's it's up to 10% of your annual turnover. And in this case, for example, if you have a subsidiary infringing competition law, because parent is also responsible, liable for that infringement, they will look at the turnover of whole company, and because of the infringement of a tiny subsidiary, you can pay a lot of money, okay? And this is actually really important, and you can see also, I'm not sure whether they have similar doctrine in the US, but I think they have something similar, because what I experienced in pharmaceutical sectors when I was practicing, if you have American company, they try to control and make sure that nothing anti-competitive happening in their subsidiaries in other countries, like for example in our case Turkey. So they have these guidelines and good practices things, try to make sure that nothing anti-competitive happening there, because they know that they can be liable for their actions, for the subsidiaries' actions, even though they are not in the States, okay, in the United States. Any questions about that? Okay. Is it hot? Okay, I'll. Actually, it's 25. It shouldn't be that cold, but anyway. Agreements. So again, agreement is one of the elements of Article 101. It's a broad concept, and it's not defined in the treaty, but we get this definition or get the sense what is agreement from the case law, okay? And the case law is, let me see, yeah, this Bayer decision, and according to that decision, in order to accept that there is an agreement, there should be existence of wills, should be between at least two parties, makes sense. You cannot make an agreement with yourself. And constituting the faithful expression of the party's intention. So as you can see, it's like a really, really broad, like if there is a, if you kind of exchange intention between two parties, then this means that there is a, this can mean that there is an agreement between those parties. And the form in which these bills are manifested, not important. So this can be oral, okay? You don't need to have a written agreement or anything. Or even, let's say there is a meeting between undertakings, and for this example, let's say companies, okay? Maybe like directors or CEO of those companies, and as a CEO of another company, you attend this meeting, and actually the others were there to agree on things, okay? And as I said, it doesn't matter whether it's written or they're only discussing these stuff. And even because you are also there, you can be considered that you are part of that agreement, okay? Unless you can prove that your intention wasn't to be part of that agreement and the others also knew that when you were there. So it's a really broad concept. And because of this, maybe you heard before, generally companies are really cautious about their emails, especially if you are like higher level director, because anything can be interpreted as like agreement if they are exchanging with other undertakings. Even like, for example, they don't want to see in the lobbies of hotels or anything together, because these things can indicate that there is something happening dodgy there, okay? So it's a quite broad concept. Decisions by associations of undertakings. We already talked about associations of undertakings, their decisions. Again, this is a broad concept. So even a decision to establish an association of undertaking can be considered as decision. And concerted practices. I just wrote this here because I think it's important to know why we have this, okay, concerted practices. What is concerted practice? Come on. Yes.
It's like a tacit agreement.
Okay.
And there's no written agreement as such as a contract or something like that, but the undertakings act accordingly to one another.
Yeah. So we can we say that practical cooperation?
Mm-hmm.
Practical cooperation between undertakings. Yeah. And why we have it? Okay. We have it to make commission work easier. So even commission cannot detect agreement. So if they cannot find an evidence of an agreement, or if they cannot find evidence of, actually I think that doesn't it's not relevant to decisions. Let's stay in the agreement region. So even they cannot evidence showing that there is an agreement between undertakings, they can still apply Article 101 through using concerted practice if there are certain indications in the market that there is a practical cooperation between undertakings. Okay, so if you have a, let's say you have a market and all the undertakings have similar prices, okay, or they are increasing or reducing their prices at the same time, maybe not like same day, but like depending on the dynamics of that market, few days or later or before each other, okay? And so it's more like to enable the Commission to apply Article 101 without finding any evidence of agreement. Okay? Any question about this? Agreements, and obviously we need to talk about this, vertical and horizontal agreements. Okay, I will wait until someone will explain me what's horizontal and vertical agreement.
Horizontal agreements is between different manufacturers, so companies or economic entities that are actually competitors. And vertical agreements is between one supply chain, so from the person who supplies the main products, raw materials, to the companies and then to the distributor.
Okay.
Supply chain, but they're not competitors, they're working together.
Yes, actually, horizontal agreements are agreements between competitors, okay? I mean, as an example, I gave this like manufacturer, like on the horizontal level, but that can be, for example, between raw material producers, okay? You can have the same line for raw material producers or wholesale distributors or retailers, okay? So if you have competitors and if they have agreements between competitors, we call these agreements horizontal agreements because it makes sense, no? It's going horizontally because they're at the same level, okay? Then for the vertical agreements, basically agreements between non-competitors, okay? So for example, between manufacturer or wholesale distributor, or between, I don't know, like manufacturer and retailer. So you can have different combinations in this vertical line. The important point is they are not competitors, okay? For example, we can give example of, again, let's say that Apple is manufacturer of a smartphone, and we said that, for example, having a distribution or retail agreement. For example, I told you that there was that third-party retailer in Turkey till 2014. So Apple had agreement with that retailer, and because they weren't competitors, that agreement was vertical agreement, okay? But let's say Apple as a manufacturer entering into agreement with, let's say, Samsung, okay? Because, and again, it's important to define the relevant market because we always decide whether they are competitors or not considering the relevant market. But let's say in the market of really broad, but like again manufacturing smartphone or like a particular technology used in smartphones, and they are entering into research and development agreement for that, because they are competitors, that agreement will be considered as horizontal, okay? which one is more can create more concerns for competition law?
Horizontal.
Horizontal, because it is,
Compete each other.
yes, because it is between competitors, okay? Object of preventing, restricting, or distorting competition. So we are still in the region of elements of Article 101, okay? We are just like going through each of them to understand what they mean. So Article 101 says that agreement is prohibited if its object is preventing, restricting, or distorting competition. Then it continues, but for now we are here. So what does that mean, restricting competition by object? Agreement restricting competition by object.
It means that when I'm looking at the effects, if the agreement has special topics, which we list here, they are automatically prohibited so on.
But why we have these, like, you're right, so there are certain agreements we accept that they are preventing competition by their object, but why, like, what makes these agreements special? I know you know, but you just need that courage to come forward and yes.
What do you mean by makes them special? As in the aim of the is to prevent competition?
I mean the other, on the other side, like the next slide is about the effect, by effect restricting competition. So, but for these agreements, we say that they are special because, and when we see that, we don't look at their effects on the market. Whenever you see one of these agreements, you said that, okay, this is anti-competitive. Okay, why we are saying this for these agreements?
Because we assume that they are against the goals of competition law, they cannot have a positive effect for economic efficiency or consumer welfare.
Yes.
Whereas the other by effects could possibly.
Yeah, okay. I call them inherently anti-competitive agreements, okay? They are, in their nature, anti-competitive. So, for example, let's say market sharing agreements, especially in the EU. If you have agreements creating boundaries between member states or isolating one member state from others, if it can be categorized as market sharing agreements, it will be considered anti-competitive automatically, and it will be prohibited in terms of, or according to Article 101. Okay, or for example, pay for delay agreements, and we will talk about that in pharmaceutical sector, prohibiting or limiting parallel trade. Again, it's related to creating boundaries between member states. So again, just to make it clear, if you have one of these agreements, and please note that this is not exhaustive list. There can be more agreements. More agreements can be added to this list. Okay, and but if you have one of these agreements, then you don't need to look at their practical effects on competition on the market. You don't make the further assessment. Just the existence of agreement is enough to apply Article 101. Okay? What happens if you apply Article 101, paragraph 1? What's the legal consequence of
Void.
Yes, void.
Void.
Perfect. At least I know that I told something. Let's take 5 minutes break, okay? And then effect is, so if you don't have this, one of these agreements are that restrict competition by object, then you have to look at the real effects of that agreement on the market, okay? And we are calling that effect of preventing competition. Let me quickly go back to, okay, yes. So this is again Article 101. So see, it says that agreements between undertakings which may affect trade between member states and which have as their object or affect the prevention, restriction, and it's going like that. So please ensure that they are alternatives. So it can be either object or effect. So if you have an agreement restricting competition by object, you don't need to look and go for effect, okay? Or if you have an effect, you don't need to also look for object. So they are alternative to each other, okay? As I said, if you don't have one of the agreements, as I called inherently anti-competitive, you have to go and look at the real effects on the market, and this also include potential competition. So maybe it's not affecting competition right now, but if it has the potential to, let's say, restrict competition in the future, you can still apply Article 101 using that by effect concept. Okay? It's not only the ones already affected or affecting, but also future potential effects. I mentioned de minimis here. So have you heard about de minimis doctrine? No? There is a de minimis notice as well? No? Let me see what I write here. Okay, what do you think when you read this? My answer is always on the slides. Just read quickly. So, what is it, de minimis?
Like,
Sorry, yeah.
there's a minimum amount of times to effect.
Yes. So there is effect, okay?
There is no minimum.
Yes.
So
It's
no
like,
really worth.
yeah. I don't want to deal with it. Like, it's not that minimal. And okay, I will try to pronounce that word, appreciable. Okay, it's so hard. I even write here like how to pronounce, but the effect is not appreciable. So it's like really minimum. No, like it doesn't work to your effort to look and apply Article 101. And in what kind of scenario do you think that can happen? Not having appreciable effect? If the agreement is between, again it's on the
Undertaking.
slide. There is an abbreviation on the slide.
SME.
SME.
Yeah,
S-
what's that? SMEs.
Small, medium. I don't
Yes,
know, just-
yes. It means small and medium-sized enterprises. Okay, so okay, this can be confusing, but just bear with me. See, market power is something we assess under Article 101, 102. Okay, market power, but it is still important when you are assessing, when you are making assessment under Article 101, because of this appreciable effect. Okay, if you are looking, if you don't have an agreement restricting competition by object, if you are looking real effect of an agreement, then that agreement in principle should be between undertakings with a
Small and big.
not big, but they have to
Middle.
have a certain, like, their market power should be above a certain threshold. There's no like a rule or something for that, but if they are really small, if their market share is really small, even they have agreement that can buy that can be quoted by Article 101, because it doesn't have that effect on the market. Article 101 won't apply to that agreement. Okay, so still market power and is important in terms of the assessment that we are making in Article 101. Okay. And finally, final element is effect on trade between member states.
Sorry, like the last sentence, is it not applicable to object restrictions?
No, so if you have object restriction, you don't need to look at the effects, okay?
Okay, okay.
So then you...
The
you
de minimis is not applicable to object.
No.
To effects.
Yes, yeah, no,
No,
de
to
minimis
object.
is related to effects, okay? If you have effect, then you have to go and see whether this effect is minimal. For example, let me... Yeah, okay. For example, there are thresholds in terms of market share of the parties of the agreement in de minimis notice, creating that de minimis doctrine and concept. It says that if you have an agreement between non-competitors, you see? Yes, if you have agreements between non-competitors, so vertical, if you have a vertical agreement, if their market share in the relevant market is below 15%, I don't apply Article 101 because effects will be minimal, okay? And then it also refers to agreements between competitors, so horizontal agreements, and says that if collective market share of competitors are is below 10%, then I consider that this agreement will have minimal effect on the market, so it can escape from Article 101 prohibition. Okay? Clear about this?
But if
Not
they,
that much.
but if they don't have the object, how can they have effect?
Good question. So, see, actually, object, if you go and look at object,
Yeah.
these agreements also have effect. So if you have, let's say, market sharing agreements, okay, or let's talk about this agreements to limit output. What happens if you limit output?
The price will go up.
Yep.
Prices
Price
will
will
go
go
up. Okay, if you limit output, prices will go up. And so limiting output and the consequences, price will go up. So you have effect here, okay?
Yeah.
But for these agreements, we say that whenever I see this, I know that price will go up and I will apply Article 101. So they also have effect, but I make it easier. We make it easier for the enforcers to apply rules, and we say that these agreements almost always produce anti-competitive outcomes. So you don't need to go and make this like detailed assessment in terms of the effects and on the market. Okay. If you don't have that kind of agreement, then you need to go and look at the effects and see whether actually there are anti-competitive effects as a result of the agreement between undertakings. Clear?
Yeah.
Okay. Effect on trade member states. We are talking about EU law, so if there is an effect, that effect should it should affect the trade between member states. And let me see. again, as you can see, there is this like may effect. So it also consists potential competition. It doesn't need to already affected or currently affecting the competition, but it can be the effect can be something like potential effect, but there should be like sufficient degree of probability. So you cannot say that I have a feeling that they can affect competition. There should be like some evidence supporting your feelings. Okay. So this issue, I think the second one is important. There is no direct correlation between geographical market and effect trade between member states. So, for example, there can be an agreement just like in the regarding the market to covering just one member state, or maybe like even smaller than that, okay? But that can still affect the trade between member states. So for example, if you have, let's say, an agreement just regarding the Scotland in terms of geographical market, that agreement can still affect the trade between member states. So you don't need to have just like players in different in different member states and agreements between them. Okay. Also, for example, even you can have situations like undertaking in a. Can you see this? Yeah. Okay. So let's say this is EU and this is non-EU country, okay? And let's say there's a manufacturer here and distributor here, and there's an agreement between them. What kind of agreement this is? Horizontal, vertical?
Vertical.
Vertical, yeah, because they are not competitors,
Yeah.
okay? They have agreement. And let's say in that agreement, manufacturer says that you cannot re-export your products into EU. Okay? Do you think that kind of provision agreement can affect trade between member states? Who says yes? 1, 2. Okay, the agreement is, so let's say it's Volkswagen, okay, selling, it has distributors in Turkey, okay, sending the cars there, but saying that you cannot re-export your cars into EU again, okay? You are contractually obligated not to re-export it back to EU. Do you think this can affect the trade between member states? Who say yes? 1, 2, 3, 5, 4, 6. Okay, why do you think that it can affect the member states?
It's the effects of trade.
Yes. So, and the one saying yes is right. This can still affect the trade between member states. So, what I try to say is that don't just like think about the agreements between EU undertakings, or again, if like for example, we can also think about like this time we can just think about Germany, for example, and this time Volkswagen imposing its distributor in Germany not to export the cars outside of Germany. This can still affect the trade between member states. So the agreement is between German undertakings, relate to, like it's in German market, but the effects are beyond the German market, and that can be caught by Article 101. Okay, clear? Okay, great. Here's my clicker.
I have a question.
Yes.
Can a government be an undertaking? Like, if they make an agreement with a company and it's anti-competitive?
Okay. Question is whether government can be undertaking. What's the answer? Can government be an undertaking? And you gave the example that if they make an agreement with a
With an enterprise and it's an anti-competitive agreement.
okay, with an enterprise
Or it's a barrier for entering the market.
okay, so what do you think? Can government or a governmental body probably? Because government cannot make it's what do you think? What's the undertaking?
Engage economic.
What is
activity.
undertaking? Yes?
Economic activity. Some
Economic, yeah.
activity. But I believe that there is an exemption from it.
Uh-huh. Okay. What kind of exemption?
I'm not sure, but I believe it's this one.
Okay.
Something about some services where it's necessary that they are being made by the government.
Okay.
Yeah, but this wouldn't be the case. Because
Okay.
It will be. I'm like the example I'm giving is like a service that could be provided for from anyone. It's not like the
Okay,
exception.
let me, for example, give me this example. You tell me whether it's like right or wrong, like in terms of what you're thinking. Let's say, like Ministry of Transportation or something like that, making an agreement for building a bridge in a city. Okay, it's related to transportation, and they made this agreement with a let's say Japanese company because they are good at doing bridges and things. So what do you think? What's the position of that governmental body or ministry in this case? Do you think that it's engaging in economic activity or? I think so. I mean, I can understand what you say. Like, if they are giving a service or like if it's related to something that can only be provided by a public body or by a public body. But actually, in this case, maybe it can be this outside of that exception because only they can make bridges. No, I mean you cannot just like randomly go and build
Yeah,
a
but for
bridge.
example, if the government that could happen well in developing countries.
Yeah.
Make an agreement and in its object it's anti-competitive, not by
Yeah.
effect. Like one of the examples you gave on the list,
Uh-huh.
prices, fixing prices, or just something like
mhm.
that. Or they are helping more a company to succeed than the others, or like communication companies, they are making barriers.
Yeah.
The basic is that if they could be undertakings or they could be subject to a.
Yes. So actually, my answer is, and I try to remember this name of the. You call them in administrative law. Actually, I'm not sure, but I'm quite sure. Probably in Germany is the same. So public bodies can establish these entities function as function like almost like a company. What's that? I don't know the Turkish English word, but I can also not remember the Turkish one. But if there is like something like that, definitely they can be considered like the undertaking. But important point is you have to look at the nature of the service or if there's like production of a manufacturing product, you have to look at the nature of that thing and whether it's only provided by a public body or on behalf of a public body. For example, as far as I remember, there was this case related to retirement homes, I think. So that governmental body made an agreement with a private undertaking for the operation and management of retirement homes. And I think in that case it was decided that it's not something, the service is not something just can be done by public body or behalf of public body, and it was considered that in that case that governmental body was undertaking and the agreement is subject to Article 101 yes, prohibition, okay? But your mission is next class, and just also look for this. I'm sure there is a case like that. Look for this, okay? I will remember it.
Do you mean state capitalism?
Sorry?
State capitalism.
It, you mean the name of the case?
The word you
Yeah.
couldn't remember. No, the word you couldn't remember.
Yeah, the word
That you couldn't remember in
Oh,
Turkish.
no. Now it's too hard. I cannot also remember the Turkish one because now I'm always like speaking English. Because of this, I cannot make the chicken translation as well. But and this is my responsibility. I will look for that word and actually look for whether there is a similar thing in here as well. Okay. Individual exemption, Article 101, Paragraph 3. Is there any other questions so far? Okay. So what is individual exemption? It's in Paragraph 3 of Article 101. Okay. Kamu iktisadi teşebbüsü is the Turkish word for that. And how you can translate that? Public public economic teşebbüs. It's a public economic undertaking or something like that. So it is coming out of like public body, but they are establishing that. By the way, don't note this. This is like just like a concept that I'm thinking how this can happen. So public bodies can establish these undertakings to engage in economic activities, and if you have that kind of situation, obviously they are considered as undertakings, and the agreements they make with other undertakings can be subject to Article 101. Okay, like the ones coming from Germany. Can you remember something like that? Yeah. So do you have that similar concept?
Yeah, we have companies which are governed by public law. So
Okay.
the state can decide if its companies are organized by private or public.
Okay.
And I think it's important for the competition law, because I think under 106 TFEU it says that the rules of competition law are apply for state companies too.
Yeah.
If they are organized by private law, but
Okay.
if they are organized by public law, I think it's a kind of state agency. So,
Yeah. Okay, so I think the right word for maybe like in English is like state companies. So companies that state actually founded, but they are organized under private law, so they are doing their stuff as like private entities, private entities. So they can definitely be subject. But then there will be state companies established under public law. They because if they are fulfilling the function that can be only done by and on behalf of public body, that cannot be subject to competition law rules. Okay, is this clear? Can I give example which one is under competition law and not under competition? I don't know like exactly like a company name or something in terms of like a company, state company. Can you think about a state company?
Is it like the train company? State-owned.
Okay, so in Denmark they have a train company, okay, and it's established by state. So actually, it's doing like it's engaging in economic activity. But if you look at the source, it's the source is state. So they get the, for example, capital from state, and but when you look at their operation, they are doing like they are working like a private company. Okay. Any other question? Okay, good. Article individual exemption. So what is individual exemption? This is the third paragraph of Article 101. So first paragraph saying is this kind of agreements are prohibited. Second paragraph saying that they are void, so remuneration for this kind of agreements. And then in the third paragraph we have individual exemption. It's actually exemption. So what is exemption?
You should be punished, but in this case you may not need to be punished. It's an exemption.
Okay. Yes, so
Can you repeat what she said?
yeah. If you can have an agreement which can be considered in scope of Article 101. So the result is being void, no. But then if your agreement fulfills the conditions mentioned in this paragraph, you escape from Article 101 prohibition. It's like a computer game. So you're going, oh, you cut, and then you can escape, okay? So, and in here, there are conditions, so you have to satisfy these conditions, and let's look at what are those conditions, okay? So it says that agreement which contributes to improving the production or distribution of goods or to promoting technical or economic progress. So this is first condition. You need to, do I have this? Yeah, okay. While allowing consumers a fair share of the resulting benefit and which does not A, B. And they are already actually here, so this table is actually copy paste from paragraph 3. I just like classified conditions. I think by now you understand that I really like charts. I really like to put things like this. So there are 2 positive and 2 negative conditions. First, positive conditions, you have to have an agreement contributes to improving the production or distribution or promoting technical or economic progress. So you need to do something related to economic efficiency, like increasing economic efficiency with your agreement, okay? This is the first condition. Then, while doing that, you also need to give fair share to consumers from that benefit. So we call that pass-on requirement. So yeah, you are doing like you are increasing economic efficiency, but consumers should feel that benefit as well. Okay. Second condition, positive, and then we have negative condition. So your agreement should have these and not have these. Okay. So the first one is impose on the undertakings concerned restrictions which are not indispensable to the attainment of these objectives. Okay, so this means that you don't have to, you shouldn't have any restrictions in your agreement which are not reasonably necessary to achieve these pro-competitive benefits. Okay, so let's say your agreement is to improving distribution of your goods. Okay, and you are actually consumers will benefit from that as well. But if you have restrictions which are not reasonably necessary to achieve that goal, you can you can't benefit from this individual exemption, okay? And then, second negative criteria, effort such undertakings the possibility of eliminating competition in respect of a substantial part of the products in question. What is this? Because I'm so tired. I'm asking you as lawyers. Just, it's the part of the text. What do you understand from that? Nothing? Yes. Yeah, so actually it says that it's good that you are doing something for efficiency, and then consumers benefiting from that, but you shouldn't use this to distort the overall competition in that market. So this second criteria is related to protection of the competition in the overall market. Okay? Before, and we actually talked about it in the ICL previous session, before the so-called modernization of enforcement of competition law in the EU, there was a requirement on undertakings to notify Commission to benefit from this individual exemption. So basically, you were submitting your agreements and say that, look, I have an agreement that can actually prohibit Article 101, Paragraph 1, but my agreement is actually satisfying these conditions, so I should benefit from individual exemption. You don't need to do it anymore, okay? Now we have self-assessment. So as lawyers or solicitors, you need to look at your client's agreement and see whether that agreement benefits from individual exemption. And in real world, what happens is that lawyers draft their agreements accordingly in a way to make it obvious that it's benefiting from this individual exemption, and as we will see from the block exemptions. Okay? Any question about individual exemption? Okay. Block exemptions, actually, they are built on individual exemption. Okay? The logic is same, but these are more specific. Okay? Commission makes these regulations, and by these they provide safe harbor to certain type of agreements. Okay? And as I said, as a logic, same logic with individual exemption, but these are more specific, okay? Particular categories of agreements. And again, if your agreement is satisfying the conditions in one of these regulations that we call block exemption regulations, then you are safe from the application of Article 101, Paragraph 1. For example, this is verticals regulations, as name suggested, dealing with vertical agreements. There is this technology transfer block exemption, and also, for example, exemption for R&D agreements, and we will talk about them in a bit when we are talking about the IP agreements, okay? But the logic is same, but there are more. Did you look at the technology transfer block exemption and R&D agreements exemption? I will ask about them because they were in the reading list. Okay, if you look at them, you will see that they are dealing with agreements, but there are certain conditions they are introducing. Like they are saying that, okay, the parties should have this market shares, or agreements should be classified under these, or then they have hardcore restrictions saying that, okay, maybe you satisfy everything in this regulation, but if you have these restrictions, I'm sorry, I cannot apply, you cannot benefit from this exemption, okay? So they are more specific version of individual block exemption. Any questions so far? No? Okay. I try to go faster, but if we can finish, we will finish next week. So now we are on the region of like how this Article 101 applies to IP agreements, okay? But before moving that, we have to talk about how you can exploit IPRs, okay? You have an IP right, how you can use that, exploit that. What's the answer? What are the ways to exploit your IPR?
License.
License it, okay. So basically rent it to someone else. So you still keep the right. You are still the owner, but you are giving the right to use to someone else, okay? What else? It's on the...
Sell it. Assign it.
Assign it. So what's assigning it? And if we... It's there.
Selling.
Yeah, so when you assign, actually you are selling your right. So you don't have anything, like when you sell, you are empty and handed. That person will have your right. And then obviously you can use your own right, okay? So if you can have a patent for product, and if you are manufacturing that patent product yourself, you are using your own right, okay? So in terms of Article 101 and 102, the first two can be, like mostly can subject to Article 101, okay? Related to market power and abuse of market power. Whereas the third one, licensing your right, can be subject to, most of the time, Article 101, okay? Because license is agreement. Money, royalty. Okay, these are the fancy words that we are using. So licensor, let's say for example patent owner, the one licensing, renting the right. Licensee, the one getting the right to use that right. Agreement between them, license, and the money is paid by licensor to licensor, royalty. Okay? So I just, in these following slides, I have few examples of how actually license agreements can be considered in scope of Article 101. So I have example for a patent, trademark, and copyright. This windsurfing case, and I think it was in the reading list, no? Windsurfing case. So what's the issue in the windsurfing case? I don't want to hear whole background of the case. So what I'm curious about, whether you get the idea of the relation between this case and Article 101 and patent licensing. Who read the case? Who read the case? Okay, I think, see, I'm not kind of lecture that I cannot force you to read anything. It's good for you to read, but it's your choice. But believe me, if there's something is on the reading list, it's good to have a look at it, okay? Just like to at least have an idea, and I'm sure most of you read it. So who read the case? Is there anyone look for the overview of the case? There are like summaries of the case, just like, no? Did you? Okay, so do you remember the issue?
I mean, stuff I wrote on does not reflect the stuff you wrote on your slides. I'm not quite sure because I focus mainly on the causes that they're not in the specific subject matter.
Okay.
So like quality controls, very challenged costs.
Okay. So the provisions in the in the licensing agreement for the, I mean, obviously it's like there are, when you have a case there are so many issues they are discussing, but for the sake of this example my aim to show you that the one of the issues in the case is whether patent covers only the rig of the windsurf or also the board. No? Am I wrong? So this is, by the way, I'm also sailor, but like dinghy sailor, so not windsurf. But this bit is rig, and this bit is board. Okay? I think windsurf they also have. This is centerboard. This is rudder, and this is boom. Okay? But for the sake of this case, this is board and this is rig. And the question is, one of the main questions is whether the patent is covering the rig or rig and board. Okay? Because there was restrictions in the licensing agreement regarding the board, I think, no? Yes. And why that was a problem? Patent is covering rig, but then there are restrictions in terms of board in the license agreement. Because at the end it was decided that, yeah, okay, it's okay, you have patent protection and you are free to use that right, but what you are doing is that you are extending that protection, okay? So you only have protection for rig, but you are extending it to board, and you have restriction in the license agreement regarding the board, okay? So the protection scope of the patent and the restrictions on license did not overlap, okay? And that was considered anti-competitive in terms of Article 101. So you need to know the boundaries of your rights, okay? You can only impose restrictions. Obviously, you can impose other restrictions, but if you are claiming that these restrictions related to your patent, actually you need to have protection in terms of that matter, and in our case, board, in your patent, okay? Constant and Grundig, what was the case? For example, this case is like, if you look at it, and it's one of the main competition law cases in the EU, and it has like a different aspect, but my question is, what was the issue in terms of trademark there? It's an important case because of, in terms of parallel import in the EU, having an exclusive distributor in different member states, and I actually mentioned this last week, this case. So, what's this case about? No one? That was also on the reading list. Okay, what happened in here is that Constant was the Grundig's exclusive distributor in France, okay? So only Constant could sell Grundig products in France. And within that agreement, exclusive distributor agreement, Grundig also gave the authority to Constant to register its GINT mark in France. Okay, and why they did this? Because then, if there will be any parallel import coming from other member states carrying the GINT mark, Constant can prevent them by relying on trademark infringement. Okay, because they were the trademark owner. Okay, and it was decided that yes, you have trademark for Grundig. You can give right to register this to another undertaking. It's your right, but your purpose is in here to prevent parallel import. So you are exploiting your right here. It's going beyond what is this main goal or core protection of that right. Okay, so they say that you cannot use your trademark to prevent parallel import, and if you do, I will apply competition rules to you. Okay, and be aware that actually IP area in general, intellectual property rights, it's one of the areas that competition is more cautious. Okay, and actually, like for example, they are more liberal in US. If you have intellectual property rights, most of the time you can escape from antitrust laws, and the only area that actually apply their antitrust laws in US is the area that I'm working, standard essential patents. But still, for example, also in competition law in the US, they are always like they recognize there is a right there, but at the same time, if you go beyond the scope of your protection, and if you are doing some things and using your right to cover anti-competitive intention or in general effect, then you can still be subject to competition law. So you should be careful. Okay, it doesn't mean that because you have right you can just like immune from competition law rules. And this will be the last one for today. In copyright, we have this Codital 2 case, and in this case, the issue was the exclusive agreement giving exclusive right to show a movie in one member state, and this was a preliminary ruling, so not like a appeal from commission or general court, and the issue was whether this license agreement can be prohibited in scope of Article 101. Okay. For this case, they didn't apply Article 101. They didn't say that it's prohibited under Article 101. But the court said that national courts should look at how this right is exploited in how they use this right in practice, and the way they are using that right can be anti-competitive. And if this is a case, then competition law rules can be applied to that license agreement as well. Okay, so that license agreement giving the exclusive right to show the movie in member state was not per se prohibited under Article 101, but there was an advice to national court, because in preliminary rulings, Court of Justice only gives its opinion. It's not solving the case instead of national court. It's just giving its opinion how to apply EU law just within the frame of the questions referred from national courts to them. And they also in that scope they also mentioned that you have to look how they are using that exclusive right in practice and make assessment in terms of competition law. Okay? Any questions? Yeah, I will quickly talk about them next week. Okay, if there is no question, we are free to go.